Good afternoon, everyone, and thanks for attending today's webinar, What Gets You in TCPA Hot Water. My name is Steve Neidick. I'm a director with CompliancePoint. I've actually been with Powell Spinell and CompliancePoint for the last 16 years. And with me is Kevin Mayfield.
Good afternoon.
Today, we're going to talk about high-risk TCPA items. Hopefully, we're going to let you know how you can avoid them, and then we'll go over some common pitfalls, some other things and areas that we see that tend to get people into a little bit of hot water or trouble. So we'll go over all those with you.
All right, thanks, Steve. So on this first slide here, we see the TCPA cases really exploded in 2013. That's when we saw the rules change on the requirements for express written consent when it comes to calling cell phones and sending pre-recorded messages. And we've seen those cases grow kind of tenfold. And there you see the average TCPA settlement, that is settlement, not judgment, is about $6.5 million. So not cheap.
No, it's expensive. And unfortunately, these changes and these rules have also brought about a new job profession for some. There's a whole host of professional plaintiffs and professional litigants out there that are actually making a living, trying to generate calls to their offices or the home phones. They're actually setting up phone rooms with multiple phones. They're going out to multiple websites, entering their phone numbers on URLs and lead gen forms, and really just trying to generate calls and then trying to get with those companies and get paid. So unfortunately, there's a lot of those out there right now. So something else to be a little bit leery and cautious of. The good news is I think the courts are getting a little bit fed up with that. I think they're realizing that there are professional plaintiffs out there. I mean, when you come across one of those professional plaintiffs' names and you type it into Google, there's a possibility you can see all of the different cases that they are trying to get out there. So in some cases, we are seeing where the judges are tossing some of those before they even get to trial. So that is some good news.
And a little bit more good news, I guess, is that we've seen the explosion in TCPA cases level off a little bit in the last couple of years. So we're not seeing that drastic increase like we were seeing. I think that probably companies are becoming more comfortable with what they need to do to comply. And they're probably doing a little bit better job at monitoring and enforcing compliance in their organization, as well as any third parties that might be calling on their behalf.
Yeah, I think it's pretty obvious that it's not the Wild West anymore out there. Smile and dial. We're not seeing that as much these days, which is a good thing. So people are certainly becoming more aware of the rules. They're cautious about it, and they want to make sure that they're doing the right thing.
Yeah, just talking from some personal experience, I know that I personally have had 3 clients at some point settle a TCPA case. One for $6 million, one for $20 million, and one for $35 million, I believe. And you got to think these are all companies that think that they're doing the right thing, and but they still end up getting stung in the end. So it's pretty ugly out there.
And a lot of times, in all honesty, a lot of these companies might just decide, hey, let's settle it, because to try to fight it in court and let it go on months and months could get more expensive. So, I mean, that's one of the downside. These professional plaintiffs are seeing these deals out there. But, again, one of the things you should do if you do get a notice or a letter or something from a professional plaintiff, obviously reply to them. If our experience has shown us in the past that, when they're hoping they kind of get ignored so they can take it to the next level, but companies that reply to them and demonstrate why they called a number or where the lead came from, usually those guys will move on. They'll go to their next victim. It's almost like a fishing expedition out there for some of these people.
So on this slide here, this is up till 2018. It kind of shows you the crossover that occurred in around 2015, 2016 of the number of landlines versus cell phones. again, this graph is a couple years old, so as you can imagine, I would expect that this gap just continues to widen.
Yeah, I think I am probably one of the few in this company that actually has a landline as well, because my wife won't let us get rid of it. So I've got both there. But in today's environment, I mean, the likelihood is better that if you're getting a phone number, it's going to be a wireless number. I mean, that may even be on a website where you're asking consumers to ask or to put in their home phone number and a cell phone number. I mean, we see a lot of people will just fill out that home phone number field, and it doesn't mean it's their landline. And we see a lot of companies or consumers rather will put their cell phones in that home phone number field. So if you're getting that lead, there's a pretty good chance it's a cell phone. One of the good things we are seeing with that is that we do have clients saying their answer rates are obviously better on cell phones than landline these days. Obviously, that makes sense because people always have their cell phones with them. They're not always at home. So chances are they're getting their cell phone into a lead form. Chances are they're going to answer it. However, if you are going to be calling cell phones and you're using an ATDS or even manually dialing, want to make sure that we have the proper level of consent to call those cell phones.
Yeah, and as more and more cell phones are out there, the ownership of the phone number becomes an issue. So, a lot of folks end up, dropping a cell phone number, and especially folks with burner phones, prepaid phones, they end up changing those phone numbers around a lot. And then now someone else has got that number, and you probably don't have the consent for that person to call them on their cell phone. So it's always something to think about.
Yeah, and here's another thing. I mean, how many clients we work with that say, "Well, I'm not telemarketing," or if we're looking at some partners of some of our clients, they say, "Well, I don't really telemarket it." It's something common that we hear a lot is across all industries as well, is they think they aren't telemarketing because they're only calling people that want to be called, or think, they reached out to me, or they made an inquiry, or they placed an inbound call. They want to hear about my goods or services. But the thing is that telemarketing is not just placing cold calls or buying lists, which again, a lot of people think it is. They kind of equate telemarketing to cold calls, and that is definitely not the case.
And Steve, another thing we hear a lot is clients that call kind of under the guise of an informational call, and then they'll transition that call. So a good example is like a survey, customer satisfaction survey, or hey, we're calling to inform you that it's time to get your oil changed. And in those survey calls, for example, for the people that are happy with the service, then they'll try to upsell or cross-sell them into other goods or services, and that makes that initial phone call a telemarketing call, even though you're leading with the survey.
Yeah, there's a good example there. A few years back, there was a timeshare company that hired a company to place outbound survey calls that was asking, vacation preferences. Do you like to vacation at the beach or at the mountains or go skiing? Which in itself probably be okay, but it depends on how you're going to use that information. And they didn't exactly use it in the right way. They took the to those surveys, and if I had said I like to go to the beach, then they would sell those leads to a timeshare company or a vacation company that was trying to offer beach vacations. So they were using the results of that survey to sell them at a later time. So in an instance like that, like Kevin just said, a survey can be a plan or program of solicitation even. So, you need to make sure that you are compliant with those rules. And it can be costly.
Yeah, for sure. Okay, this side here is about TCPA. Is not limited just to telemarketing calls. We see cases all the time in debt collection and other informational type calls. The pizza chain that sent the texts, the gym that sent the texts, clothing retailer sending texts. Again, all these companies were in this thinking they're doing the right thing, and you can see that the the fine amounts or settlement amounts get into the tens of millions of dollars. So compliance can't be taken lightly.
Yeah, I mean, that's a lot of money for a lot of these companies. Again, I don't know if you've heard that little acronym, the TCPA. I mean, there is the Telephone Consumer Protection Act, but they also say it's total cash for plaintiff's attorneys. So a lot of these enforcement actions here with all this money, the plaintiff's attorneys are getting huge chunks of this money, whereas the class maybe not as much. I can think of one from a professional sports team that had a hefty $3 million fine, and that the lawyers raked in a lot of that money, while the class members each got between a $50 and $75 gift card to the team's pro shop. So, these enforcements are big, and it's lucrative for these plaintiffs. So that they continue to go after people and look for clients to get, on their side.
Yeah, even those settlement amounts in 16 million, 14 million, the plaintiffs' attorneys are getting between $2 and $4 million bucks, out of those deals. So I mean, it's a lucrative business for them for sure. So you really have to scope out, who you're going to be calling, why you're calling them, and how you're going to be contacting them. So talking about the who, for instance, am I going to be contacting inquiries, or am I going to be contacting past customers, that type of thing?
You need to figure out, you could be calling current customers who may have given your phone number long ago, or given you consent to place calls or even cold calls. So it's important to know who your audience is, who these campaigns are reaching out to, and what those rules are when you're placing these campaigns.
Right. And then you have to think about why, right? So, am I calling for informational purposes, or am I calling for sales purposes? Am I calling for dual purpose? We see this a lot where clients, like I said earlier, try to fit them into a box of informational so that they don't have to worry about do not call and the higher level of consent if they're calling cell phones with an auto dialer. But if it's a dual purpose call, then you need to be honoring the stricter rules under telemarketing, kind of like the example for the oil change reminder I talked about earlier.
Yeah, and that oil change too. Some clients might think, well, that's informational. I am just calling someone to remind them we're keeping records and we're showing it's time to change your oil. But a regulator or a court may not feel that that's the same case, because really I can get my oil changed anywhere. I don't have to go back to the same place for the dealership. So, chances are that's more of a solicitous call than it would be informational. But lastly, you want to determine how. How are you placing these calls? Are you placing them on an automated telephone dialing system or an ATDS? Are you manually calling these numbers? Are you sending out texting campaigns or pre-recorded messages? So these are all things you really need to be paying attention to make sure when you're starting these campaigns that you are complying with the requirements. So here, what is getting companies sued under the TCPA? So we're going to talk about these, dig into these over the next few slides. Again, the auto dialer, automated versus manual dialing, consent, making sure you're obtaining an adequate level of consent to call and text. Opt-outs, we want to make sure we're honoring opt-out requests. And then lastly, wrong parties, calls and texts to the wrong parties, like Kevin mentioned earlier. Cell phone numbers change quite frequently. So just because someone gave you consent 2 years ago does not mean that same person owns that cell phone. So what are some of to get into the ATDS discussion, some of the differences in the definition of an ATDS. So the statutory definition of an ATDS is equipment which has the capacity, A, to store or produce telephone numbers to be called using a random or sequential number generator, and B, to dial those numbers. But some of the other things we need to consider here is because kind of courts are all over the place when they're deciding whether it's an ATDS or not, is end user perception and dialing modes and the capacity of the dialer. We run across a lot of clients that are placing campaigns and dialing in a preview mode or a manual mode for every campaign. And in their mind, well, each and every one of these calls requires human intervention, which the FCC has had commentary on. But the issue is the dialing platform they're using has the capacity to dial in other modes without human intervention. So therefore, even if I'm dialing every campaign and every phone number manually or in that click to dial mode rather, those are being done on a system that can dial without human intervention. Therefore, it's likely it's going to be considered an ATDS. And the other thing, when we go back to talk about the professional plaintiffs, they're assuming every call they get, whether it is or not, they're making the assumption that this is an ATDS, so I'm gonna go after you. Now we have seen some recent wins for defendants here. Many circuits are going with the statutory definition on the 7th and 11th. They have very narrow interpretation of the definition, much like the statutory definition.
Yeah, that's right, Steve. And, we've seen some circuits going the other way. We've got the 9th and the 2nd circuits have a much broader definition of what an ATDS is. There was one case in the 9th Circuit, Marks versus Crunch Fitness, where the court said that the term automatic telephone dialing system means it's equipment which has the capacity to, 1, store numbers to be called, or 2, to produce numbers to be called using a random or sequential number generator and to dial such numbers. So they're saying that if the system has the capacity to store numbers and dial such numbers, that is an ATDS, and that is an extremely broad definition for now, and is the law of the land in the 9th Circuit. So, our fear is that we're going to see a lot more professional plaintiff types running to the 9th Circuit when they can to file their court cases on these ATDS rules.
So, what can you do to protect yourself? One of the first things that we advise clients when they're asking about an ATDS or not is one, if they had a dialer analysis performed. And, first thing, obviously, reach out to their platform provider and ask them if you had any independent third-party analysis. You don't want to rely on them, your dialing company, saying, yeah, we looked at it and it's not an ATDS. Of course, they're going to say that. What you really want to do is get an independent analysis or ask them if they've had one performed and if they can share that with you. It's pretty important to have a non-biased approach to that. And you want to have that in writing if need be.
Yeah, I mean, even those aren't, 100% bulletproof, but at least you would know that somebody has looked at it and come to the conclusion that it was not an ATDS. Some potentially good news on the horizon on the definition piece is that as of just last week, the Supreme Court agreed to hear a TCPA case against Facebook, and hopefully, and that's in air quotes, that case should clear up the definition of an ATDS moving forward. I think that's on their docket when they come back in October. So they're going to hear that argument sometime in the fall. So I would expect that we would, hopefully by the end of the year, we'll have some clarification on that.
So some of the do's and don'ts here, like I just mentioned, just to kind of reiterate that is, obviously you want to have the independent dialer analysis performed. You can have that done. There's CompliancePoint does those. Third-party law firms do those. I can't emphasize enough, though. You really want to make sure that the dialing platform, that you'd be safe and that, confident that a court would find that it's not an ATDS. So it's a pretty big do there and should be high up in the list. And then, obviously pay attention to the court rulings on various ATDS platforms. There's a lot out there that continue to happen. So just kind of watch those, pay attention to what's going on out there in the environment.
Yeah, that's a good point. I mean, certainly a quick search of the internet of your dialing platform that you're using in TCPA, you may be able to glean some information from past cases on the platform that you're using and feel better about it at minimum. You certainly don't want to assume that you're just because you're manually dialing that's a court's going to agree with you that system is in fact a manual dial platform. It kind of goes back to what Steve was saying. If you're just using it in that mode, that if it has the capacity to dial otherwise, it could still be an ATDS. And you don't want to use a dialing system that doesn't require human intervention for each and every dial. So what we're saying here is that typically true manual systems, agents will hear the ringing, they'll hear the answering machine, they'll hear a busy signal. What gets people into trouble a lot of times is when professional plaintiff type answers the phone and they hear a second or two of dead air and then it's connected to an agent. That's a telltale sign that is likely an auto dialer. So anyway.
But also it could be a manual platform. That's another thing. You want to make sure that your agents are trained that, when they get a consumer on the line, that they're speaking to them right away. Because just like Kevin said, a lot of companies, these plaintiffs will hear a beep maybe and think automatically, okay, they're dialing me on an ATDS, I'm going to go after them. So there are some things you can protect yourselves from there. And then consent. As we've just been talking about, consent is very important in all of these. If you're using an ATDS and you are calling cell phones, there are key components that the consent disclosure language should have. One, that the entity who is going to be placing the call, the specific telephone number that's being given consent to receive calls, the fact the calls will be placed for telemarketing purposes, that the calls be placed using automated technology, and then lastly, that consent is not required to purchase. So in this example here, you can see that it contains all of those elements. Big thing here is it needs to be clear and conspicuous. Can't tell you how many times we've reviewed disclosure language on lead forms and it's barely visible. You can hardly see it. It's in a small font, or it's in a grayed out font, or it's at the bottom of a page or nowhere near the field where a consumer would enter their phone number. So that's a big thing, is clear and conspicuous.
Yeah, and also no pre-checked boxes. You'll see this particular disclosure here has an unchecked box where I can consent to that. It might also be done by clicking the submit button below, you consent to receive automated calls and texts and so forth. Got to keep records of the consent as well. If you don't have a record of it, it never happened. So it's fine that you're gaining consent, but are you retaining that consent and can prove 3 years from now that Joe Jones consented to that automated call on his cell phone? And you can't make these agreements part of any larger agreement or terms and conditions or privacy policy when it comes to telemarketing to cell phones. So you can't bury it in the contract. You would have to have an unchecked box where they took some sort of affirmative action to opt in to the express written consent. You can't have it in your privacy policy, like I said, and so forth. It's got to be out front at the time that they're submitting their phone number that you're wanting to contact them in this way. And also, if you've got lead generators that are working on your behalf and they're gaining the consent, it's your responsibility to ensure that they are gaining the proper level of consent for you to place those calls. So, ultimately, you're the one on the hook. You can't contract away compliance, and simply, put that in your agreement with the lead generator that they're gonna do everything they do to make sure you're TCPA compliant. You have to be monitoring and enforcing that.
Yeah, and another thing that happens quite a lot is the confusion between what is express consent versus express written consent. So basically, express consent would be required to place informational, debt collection, customer service type calls, anything that's really non-solicitous. And express consent, in that instance, the FCC has made some commentary that provision of the phone number, absent instructions to the contrary, could serve as express consent. So, for example, if I signed up for cable television and during the process I provided my phone number as my contact number, and then I stopped paying my bill, I've given my express consent by providing my phone number that the cable company could call me to collect on that debt, so to speak, versus express written consent, which is really the requirement to place solicitous marketing type calls to cell phones with an ATDS. So when it says written here, it doesn't physically necessarily have to be written. It could be, an electronic signature under the e-sign act. So for example, if you had the agent read certain disclosure language on an inbound call and that consumer consented to calls and gave the phone number, again, it was clear and conspicuous, and they gave their express written consent, and you keep records of it, that could serve as express written consent. Or like the example above, I go to a website, fill out my information, give my phone number, hit submit or check that box, and you keep records of that. The date and time that I provided my information and what that page looked like at the time I entered my information. That could serve as express written consent. Again, the important thing, you want to be able to track that down. That's what these professional plaintiffs are relying on, people not knowing where the lead came from. But if you can, shoot them back a response that shows, well, you went to this website on this date and gave us this phone number, you're creating yourself a better defendable position there. And then lastly, consent is not valid after the opt-out. So obviously, we just want to point this out that you did get express written consent to call someone, say, a year and a half ago, but somewhere in that, after that time, they had revoked their consent or requested no longer to be called. That trumps the consent there.
Yeah, on that slide earlier where we were showing those fines, it's amazing how several of those were, people receiving texts, for example, and they said, stop texting me, and for whatever reason, it wouldn't get honored, right? So whether, they're texting with different systems that weren't talking to one another or whatever it was, you got to make sure that, you're honoring those opt-outs. So another slide of action items here. You do want to ensure that express written consent disclosures contain all those key components. We review a lot of these disclosures on web pages and so forth, and it's incredible how often they get changed and without the right people knowing and approving those changes. So you definitely also want to have a policy on approving new methods of gaining consent. So, we see this a lot as well, where sales or marketing will partner with a new lead generator and not run that by anybody because they didn't know they needed to, because there's no policy around it. And you do want to definitely ensure compliance of all your third-party lead sources. Again, that's on you. You need to be doing your due diligence to make sure that anybody generating leads on your behalf is doing the right thing. And lastly, you definitely want to keep records of everything.
Yeah, and for the don'ts, we talked about this, but I can't emphasize it enough, is make the disclosures. You can't make the disclosures hard to read or find. That is going to be your best defense, is clear and conspicuous disclosure language. There it is. There's no way you could have missed it. And that's your defendable position. Don't assume consent can't be revoked even on informational calls and texts. Remember the revocation of consent, if you're using an ATDS, isn't just for marketing calls. It can be informational calls and text messages. And then lastly, don't let the wolf guard the hen house. And I guess what we mean there is sales and marketing has one job, and that is to sell and market, right? So they may not be fans of having disclosure language somewhere that's easy to see, but we want to make sure that they are not running the show here because, again, they're just trying to generate sales, get that business. We in compliance and legal need to make sure it's being done in a compliant way. So we need to make sure we're vetting those things and getting approval there. So failure to honor opt-outs. Again, opt-outs have to be honored by any reasonable means, over the phone, through text, through email. That case that's listed there, Van Patten versus Vertical Fitness, is a good example there where Mr. Van Patten thought that, since he quit his gym membership, that he was revoking his consent and that he should be on the DNC list. And that wasn't necessarily the case. Just because he quit the gym membership, he didn't make any clear request that he didn't want to be called any longer. So that was actually a case that went on the side of the defendant. It wasn't clear. He didn't make a clear effort to make an opt-out request.
Yeah, one of the more difficult things that I see clients struggling with is when they are making automated dials for both marketing purposes and informational purposes, and not honoring consent revocation or opt-outs across all of their contact or communication methods. So if you call me on a debt collection call, and I revoke my consent, then you should not be automatically dialing me on a telemarketing call. Probably the harder one though is the other way around. When you call me on an automated marketing call and I revoke my consent, say stop calling me at this number. I then become a customer, and I get an automated text saying that the technician is going to be out, on Tuesday. Well, I've revoked my consent to be auto dialed on my cell phone, and when I did that for any purposes. So it's just important that you guys are managing that somehow.
Yeah, and calls and texts should be treated equally. The thing here is if you've got disclosure language that someone opted into where they agreed to receive phone calls and text messages, and then they opt out, you should really apply that to both. Since you gained that consent in both methods, you should opt them out in both methods. Where it might be different if someone opted in via a preference center and selected one contact method over another, and then they opted out of one. Maybe that doesn't apply to the other, but a lot of the companies we work with, they're kind of grouping those opt-ins together. They should be grouping the opt-outs together as well. Some of the do's and don'ts for this slide. Obviously honor opt-out requests as soon as possible. You don't want the agents to hold them for a week, and you definitely want to honor those as quickly as possible. Should create a revocation of consent list in addition to the DNC list. Like the example Kevin just mentioned, you might be running informational campaigns. You're not going to scrub those against your do not call list because it's not necessary. But if someone revoked their consent to be called on a cell phone from an ATDS, they don't want to be called. So it might be more useful to keep separate lists there. Again, honor opt-outs across all calling and texting platforms. And then ensure opt-outs are recognized across all departments. A lot of times too, we've gone into companies and there's pockets of DNC lists. One department might have a list in this database, another department might have a list in that database. You want to make sure you centralize those that's recognized across all departments.
Yeah, and you can't assume everybody in your organization understands how to opt someone out. So, the FCC has said, someone can revoke consent in any reasonable means. That's pretty subjective, right? So what we recommend doing is that you take anybody that's customer facing, and you make sure they understand the importance. If someone says, stop calling me, stop texting me, that they know how to take care of that or escalate it to the right person that does. It may not be, the cashier or the store clerk that needs to know. I wouldn't necessarily say that that's reasonable, that someone could think they could tell a store clerk that they wanted to stop receiving calls, but certainly anybody, interacting over the phone needs to understand. Also, you want to make sure you're not transferring email opt-outs or email unsubscribes to calls and texts. So that's two different things, and you could be, over suppressing in essence by transferring email opt-outs and making them also subject to the calls and texts. And you don't want to utilize manual platforms to telemarket to your DNC list. So, if somebody on an automated call, somebody says, stop calling me, that doesn't mean that you can then just flip them over to the manual system and continue calling them. You could for informational purposes, but not telemarketing.
So there's wrong party contacts. I mean, we talked about the number of cell phones early in the presentation, but there are about 100,000 cell phone numbers that are reassigned on a daily basis. It's a lot of numbers. So we just need to make sure that we are paying attention to whether it's a cell phone or who that phone number belongs to.
Yeah, especially in debt collection on that one, because we tend to see when people aren't paying their bills, they're tired of getting phone calls, and they switch phone numbers. So we see a lot of reassigned number or wrong party cases when it comes to debt collection. But you really just want to mitigate the risk on these wrong party contacts. So inbound calls are a great opportunity to confirm someone's telephone number. So if your organization's receiving inbound calls, train your agents to confirm the best contact numbers on those calls. And one of the most, the things that we see the most when it comes to wrong party contacts in call centers, and it's really just a lack of agent training, is you want to stop calling wrong numbers, right? So train the agents that if they're calling Joe Jones and they get a voicemail for Sally Smith, that's a wrong number. If they receive a tritone for the number being disconnected, make that a final disposition on that, and don't call that number anymore.
Yeah, and it's hard. There's no real good way right now to determine who owns that cell phone number. A couple of years ago, 2018, the FCC did come out with a report and order kind of mandating the wireless carriers to come up with a reassigned number database, really showing who owns a phone number if it's changed hands. That initially was slated to come out at the end of 2019. I think it's proving a little bit more difficult and complex than they thought. That is now scheduled to come out at the end of this year, 2020. But there are some things you can be doing in the meantime. There are scoring databases out there through various companies, CompliancePoint, Possible Now, Newstar. There are others where, again, it's not going to be 100% accurate, but you're going to be able to get a pretty good idea of whether or not the same person owns that cell phone number that you have in your possession. So you can make an effort and just do your best until that database comes out. That's really all you can do right now.
So you definitely want to pay attention to the status. The FCC mandated disconnected reassigned number database. Kind of keep up to speed on that and when it's coming out and when it's going to be available. And you can do periodic mobile scoring on your database. So you don't have to do it every day. You don't have to do it every month, but Maybe every 6 months, you want to take all your cell phones in your database that you might call in the next 6 months and perform a score on those numbers and the likelihood that they still belong to the person that you think that they do. And you can you definitely want to dial manually if you're unsure about the accuracy of the group or the bucket of leads that you're going to be calling. If you think that it might be likely that a lot of those numbers have changed hands, you can alleviate that risk by dialing those manually.
Yeah, and some of the downs, like we just talked about, assume you're calling the party you think you are. Again, cell phone numbers change quite frequently. You need to make sure that you're calling the right person. So don't assume the number you have, that person still owns that cell phone. And then lastly, continue to pitch a sale if a wrong party is contacted. So obviously if you're calling someone trying to sell them a newspaper and the person you called is someone other than who gave you that phone number, that consent, don't continue to pitch them. Apologize, end the call. Again, ultimately, we're trying to reduce consumer complaints and continuing to pitch someone who you're trying to reach out to that doesn't want to hear it will certainly lead them or could lead them to submit a complaint.
So there are a few other pitfalls that we see common than just related to TCPA, right, Steve?
Yeah, absolutely. The state rules, a lot of companies who we work with or begin working with, might be familiar with the federal rules. They do a good job of complying with those federal rules, but they might not be aware that there are state rules that have more restrictive requirements. There are 12 states that have their own state DNC lists. Really need to pay attention to those rules because unlike the can-spam laws, federal rules do not preempt state rules when it comes to the telemarketing laws. We need to make sure we are complying with the most restrictive rule.
And also, some states require consent regardless of how you're dialing. There's several states out there that you can't telemarket to a cell phone without consent. So, also called party location, we see this a lot, very common amongst our clients, where they are determining the consumer's location based on the telephone number that they have. Now, obviously, if you're only getting the telephone number, then you can only do what you can do, right? But there's nothing worse than thinking that you're calling someone at 8 a.m. on the East Coast when it's actually 5 a.m. where they're sleeping on the West Coast. So obviously, if you have the zip code, if you have the state, use what you have to make the best determination on where someone is located.
Also, call recording disclosures. I think people are so used to hearing that on the phone now. We always advise making that, have the agent make that call recording disclosure 100% of the time. There's one-party states, which mean the agent needs to be made aware. Two-party states means the agent and the consumer. California, if you look up their call recording disclosure cases, they do go after people. There's been some pretty hefty fines for agents not stating that those calls are recorded. So, and also we don't necessarily know where a person is located because of number portability. So we generally advise just make it on every call. Like I said, people are used to hearing it. It takes the complexity out of the agent's hands to try to determine where is this person at that I'm calling. Just make sure that they're making that on every call.
The last pitfall that we commonly see is when it comes to cell phones. And there are two lists to identify cell phones out there that need to be used. There's the wireless block identification list. That is blocks of telephone numbers that are known to be assigned to wireless carriers. And then there's also the ported number list managed by iConnective. That is phone numbers that are ported from landline to cell phone, which is why they wouldn't be caught on that first wireless block identification list. Per the TCPA, you've got 15 days to identify when a number is ported. So if you're making auto dialed calls, you think you've identified everything as a landline, and the campaign's running for 30 days, and 16 days in, a number of ports from landline to cell phone, you're not going to know about it unless you have a process in place to identify those telephone numbers. All right, everybody, we're going to open it up for questions here in just a second. Just want to let you know that you will receive the presentation as an audience member. That'll be emailed out following the presentation. And we also supply an email address there if you have any questions after the presentation. But we are going to open it up for questions. We would urge you to use the chat box or the Ask a Question button to submit your questions. And then Steve and I will provide you guys with some answers here.
All right, it looks like we have some questions here in the question box, so we'll get to these. For long-term substantiation of consent, do the products at market that record the web session hold water as a record of consent for substantiation purposes? So I say yes. Basically one of the things there, as long as that website keeps track of what that page looked like on that day and time that consumer filled out their information, and you have record of the information that they put in there. Again, as long as you had clear and conspicuous disclosure language, and you can, have records of that and pull it up at a later date, that should serve as evidence of consent, right?
Yeah, I would agree. I mean, I would think that's really the gold standard these days. Some of those services I know do a very good job of identifying if proper consent disclosure language is present on a page. I don't know how good of a job that they do of determining whether it was clear and conspicuous. So, there may be some manual work on your end that you need to do to look at any pages that you have out there that the disclosure language is clear and conspicuous.
And obviously, again, you still want to make sure that the person you're reaching out to that gave you the consent is still the owner of that phone number.
Right.
All right. Next question. If we received consent for contact via automated technology without specifying calls, does that also allow SMS marketing?
I would say no on that. I think that's something that you want to stay away from. I think that you want to ensure that that you're identifying how you're going to be contacting the person, and that again it's clear to the consumer what it is that they're consenting to. So sure, I'm consenting to be contacted via automated means. Make it an email, right? So any professional plaintiff with their assault, right, is going to say, well, yeah, I consented to that, but I certainly didn't think that was going to mean a call.
Yeah, you shouldn't get so specific or make that so broad in contact, like you said. Maybe I thought I was getting an email and I didn't want to be called or texted. So you should make it specific to what you are trying to, what method of contact you're going to use. Next question, are there any specific states that require consent to call cell phones when manually dialing? So there are a handful of states, specifically Arizona, Louisiana, Texas, New Jersey, and Wyoming, off the top of my head. So even if you are calling those with a manually dialing platform, you would still require either some type of consent or, with Wyoming, an established business relationship.
Yep.
Anything you want to add there?
No, I think you got it.
Next question, how much impact does state registrations play in TCPA?
I mean, it's really two completely separate things. When it comes to state telemarketer registrations, certainly letter of the law, you need to be doing that if you don't have an exemption that's available to you. We don't typically see that lack of telemarketer registration as being a primary reason for an investigation, if you will, from like a state AG. It would more generally just be a red flag if there were to be a complaint come in about you and you weren't registered in that state. Was that kind of what you would say?
Yeah, I agree. Yeah, it's two different areas of two different requirements there. So,
yeah.
Next question. If I'm using an ATDS and I'm gaining consent for calls and texts separately using a customer's preference center, am I required to make the TCPA disclosure on both options? Again, there I think it's a preference center, assuming you're using something with radial buttons where they're choosing which ways they want to receive communications. If you put that language next to those fields, again, the key factor with all this, it's got the right language in it and that it's clear and conspicuous. Again, we don't want this, small font size or hidden in terms and conditions or privacy policy or anything like that. I would say if you're doing it, you're collecting it all the same spot, it's clear and conspicuous, you could just state that disclosure language once.
Yep, agreed. I mean, if you're doing it on different pages for some reason, you would want to make that disclosure, on both of those different pages for calls and texts. But if it's all right there together with unchecked boxes, I think it's fine just to have the disclosure one time.
Next question. Can TCPA opt-in consent be obtained from existing customers through automated text messaging? Alternatively, can automated transactional text messages direct consumers to their account preferences website linked for opt-in?
Well, you certainly can't send a text via automated means asking them to consent to texts via automated means, right?
Right.
So, that'd be kind of like calling someone on the do not call list and asking them if they wanted to continue to be called and marketed to. So, I don't know, that answers.
Yeah, I mean, I think the question, no, you can't send a text trying to get consent since you should have had consent before you sent the first text to begin with. So
Right.
You definitely did. And then the second part of that, automated transactional text message directing consumers to their account preferences link for opt-in. That's a little bit fuzzy, I think, there. I mean, yeah, that might be an informational message since it was transactional, but part of that message is directing them to another page where you're trying to get opt-in for marketing purposes. I mean, what do you think about that?
Yeah, I mean, same. Okay, so I get an automated text saying that my order has shipped. It then gives me instructions to visit this page to update my preferences, and once I get there, you're trying to get me to consent to marketing messages. I think you're trying to get around what the nature of the law was intended to do.
Yeah, agreed. Okay. Next question. If a consumer states, do not call me on a list for client 1, can a call center call that same consumer for client 2?
Yeah, I mean, you will have some really savvy consumers out there that says, that understand that you're a third-party call center, maybe making those calls, and they say, hey, who do you work for? And you say, I'm ABC telemarketing firm. Well, I don't want any calls from XYZ company, and I don't want any calls from your company either. In that case, you would need to add that to your call center, basically, company do not call list, and then suppress those numbers across all clients.
Yeah, agreed. Do I need consent? Actually, hang on, one just jumped in here. Do I need consent to call/text my loyalty base or members when sending out coupons and sales-related messages? So basically, again, you need that consent just based on the fact that they're a loyalty member or a current customer, but maybe they've never provided you with consent to receive calls or text messages, doesn't mean you can do that. So you do need consent to be able to still send them a text or call them if you're using an ATDS.
Yep, totally agree.
Next question. What tends to be the biggest starting point for professional plaintiffs? Internet leads with weekly compliant web forms. In other words, a mortgage form request without consent language would seem an obvious target. Or are there other preferred traps? Is there a database at market with a list of known plaintiff numbers? Well, there is
not a formal litigator list out there, but there are compiled litigator lists out there. Our parent company, Possible Now, has one of those litigator list, and we do work to look at cases. And when we come across names and phone numbers of known professional plaintiffs, we put those numbers on that list. We also work with third-party law firms that send us numbers, and those numbers get put on that list. But you're right. There's a lot of different ways that these professional plaintiffs are working out there trying to generate calls. They're going to multiple web forms. We've seen the same person go across multiple web forms across different industries, same name, same phone number, trying to get money. So that's usually where they start first is with the web forms. Anything you want to add there, Kevin?
Yeah, I would just say that I would say that more often than not, the cases that we've seen have been, kind of like we said earlier in the presentation. Somebody receives a call, and they hear that click or they hear that dead air, and whether they gave consent or not is really a moot point. At that point, they're going to try to come after you.
Yeah, and again, even from inbound call recordings, maybe they're hoping you're not doing a good job, or you're not holding on to your recordings long enough, or you wouldn't be able to find the recording where they gave consent. So, yeah, it's best to keep track of those. So, just to be cognizant of everyone's time, we're at the top of the hour. It's 3 o'clock, so we will not be taking any new questions. Certainly reach out to us, though, if you still had a question that we didn't get to or need some information. Definitely reach out to us, and we'll certainly get back to you pretty quickly.
And thanks for the time today.
Thanks, everyone.